For those on Zoom tonight, we want to welcome you. For those here tonight, we want to welcome you as well. My name is Justin Schreier. I'm the communications specialist for the town of Cohasset. We're going to hand things on over to Janelle with KP Law, who's going to take us through some ethics and open meeting law training tonight. But before we do begin real quick, I just want to take a moment to remind everybody when boards and committees are on Zoom, there was always an open mic. So I think that's best to remind folks every year that you are always being recorded once you enter into that Zoom room. And for now, we'll send things on over to Janelle with KP Law. Janelle, take it away whenever you're ready.
Thank you, Justin. Thank you, everyone, for joining me this evening. I appreciate everyone's time and effort, and we're going to get into the presentation. We're going to cover the sunshine laws tonight, and I'm just going to do a screen share so everyone has all the materials in front of them as to what we're going to be discussing. And I appreciate everyone's patience while I just get this up and running for 1 second. Okay, hopefully everyone can see that clearly on their screens, both at home and in person. My name is Janelle Austin. I work with Carolyn Murray at KP Law. We're here to talk about the sunshine laws this evening, some public records law, open meeting law questions, and really to cover best practices and overview of the laws as they are this evening. As of this evening, there were some last minute developments over the weekend with respect to the open meeting law. So we'll talk about that a little bit in terms of legislation that was passed. We're going to take a break in between the first portion of the training after the public records law. Happy to answer any questions that anyone may have. We'll go through the open meeting law section, which is a little bit longer. After that, we'll pause and we'll certainly be able to answer any questions that anyone may have as well. I appreciate Justin's reminder at the beginning of this webinar, and would also say the purpose of the training and presentation this evening is, like I said, to go over an overview and best practices guide under these statutory schemes. I would say, and just remind anyone attending tonight, that this isn't a forum to provide any specific legal advice, and we'll get into sort of the disclaimer on that, but really just to provide an overview and best practices in terms of where the laws currently are, some practical advice as you navigate on your particular boards and commissions and committees, and certainly where the Division of Open Government and the Supervisor of Records sees things as in these evolving areas. So just wanted to go over that at the outset and say it's really not a forum to go over any specific questions or inquiries. Certainly, if there are any, we're always happy to help, just to contact the town manager's office and go through there. But we're going to really just get into best practices and overview. So that's what this disclaimer says. Obviously, we're not going to get into specific issues, but really just to go over an overview of these statutory schemes. So we're going to start by going through what sunshine laws are. And states have sunshine laws to promote government transparency. All of you, of course, that serve on boards and committees and commissions for the town understand the importance of the open meeting law, the public records law, and the conflict of interest law. And these laws exist in every state. In Massachusetts, we have the open meeting law, and that is enforced through the Attorney General's office. It has a specific division. Attorney General Maura Healey has a specific division, the Division of Open Government, that is charged with enforcing the provisions of the open meeting law. The public records law is enforced through the Public Records Division and the Supervisor of Records, as many of you know. And the conflict of interest law is obviously enforced under Chapter 268A and the State Ethics Commission. The purpose of these laws is to eliminate secrecy surrounding decisions and deliberations on which the town's public policy or government operations is based. Under the open meeting law, as you all know, public bodies can only conduct business through public meetings that are properly posted and held in accordance with the provisions of the open meeting law. Public business needs to be conducted publicly, openly, unless there's a specific exemption, which allows a board or committee or commission to enter into executive session. We'll talk about that in detail as we get into the open meeting law session of the training. But certainly you want to be cognizant of the general proposition or principle that public business is conducted publicly, open and transparently. Excuse me. Under the public records law, as we all know, virtually any record that's created or received by a government employee or official is subject to mandatory disclosure. Those are records created by the town, an employee of the town, official of the town, a board member of the town. And so we're going to talk about, how to maintain records and how to be cognizant of the requirements of the public records law. So we're going to start with the public records portion of the training, and certainly with the notion that all books, papers, maps, photographs, recorded tapes, generally records in hard copy or in electronic form, regardless of how they're created, as long as they're received or sent by a public employee or official, are subject to the public records law. And the overarching principle is really that we're focusing on the content of the record versus, whether it's on someone's personal email account or personal cell phone. It's really records that are sent or maintained or received in someone's capacity, in his or her capacity as a on town business or government business. So the definition really focuses on the content and the possession. And that's why it has been extended in recent years to be interpreted as including text messages or emails to personal accounts if they deal with town business. I did see a hand up as part of the presentation. If it's okay, we're going to go through the public records portion, and then we'll certainly answer any questions on this before we get to the next one and allow people to take a break. And Justin can help me with that if he doesn't mind. So the use of municipal or town email addresses or creation of specific email addresses for town business is highly encouraged. It allows us to obviously search records in response to a public records request and ease the town's burden if records have to be produced. But it also allows people to not have to deal with records retention issues as much on their own personal or work email addresses. It allows that segregation of those records. And notably for this training tonight is, an officer or employee of the town includes volunteers and the records that are made and received in a volunteer capacity for the town. The town has designated, as you all know, a records access officer. That's the individual that's charged with overseeing the town's response to public records requests. Towns designate more than one RAO, the police department, the school department. There may be multiple records access officers to streamline and be very efficient in terms of answering public records requests. And certainly the duties include assisting requesters and record custodians, department heads, board chairs, committee chairs, commission chairs, in terms of gathering records as necessary and really streamlining and ensuring the town's response, as we'll talk about in the next couple of slides. So part of the sunshine laws and transparency and openness in the town is really the town will receive public records requests, and then it will send a response to that records request. A request under the Massachusetts Public Records Law can be made in person or in writing, by regular mail, obviously by email or electronically, which is the most common form at this point, or fax. We see that once in a while, particularly from out-of-state requesters. But the records access officer or the individual who's been designated to respond by the records access officer has to respond within 10 business days following the date the request came in. So if a request came in today, day one would be tomorrow, and a response needs to issue. We'll talk about that response within 10 business days. Saturdays, Sundays, and legal holidays are excluded. And if the records aren't provided, a detailed response does need to be provided indicating why those records are going to be withheld or why there's going to be an estimate for a larger request. So we'll talk about that a little bit. But really the focus is on understanding that the public records law exists and that you may be called upon to produce records or facilitate a response to that request in your capacity. So the Records Access Officer assists requesters and records custodians, including board members and public body members, to answer a public records request. That may include gathering meeting minutes or other records that were part of a meeting, but certainly you may be called upon in your capacity to assist with that. The goal is really to have an efficient response system, and so the more care and management is taken into the records that you all have, the easier it is to respond as necessary to a public records request. In a full response, if a full response cannot be provided within the first 10 business days, the Records Access Officer can provide an initial response asking for an additional time period. But in a minimum, something should go out within those 10 business days, and that should be done in writing if additional time is required. For large requests, and we're seeing more and more of these across the state in our experience, Carolyn and I, if there's a very large request and it may take a significant amount of time to respond, the town would often say, can you narrow the request? Can you provide keywords? Can you help? Because this is going to be burdensome or onerous. And sometimes an individual may say no, and a fee can be assessed for the time to search for and locate those records. In order to do that, however, a response must be sent within 10 business days or else no fee can be assessed. So that's an important time frame. It comes up pretty quickly. And if the 10 business days goes by, it could potentially be a waiver of the town's ability to charge a fee. So the timing for responses: provide the records or an initial response within 10 business days. The public records law does allow extensions under pretty narrow circumstances in my experience. There are petitions that can be filed with the supervisor of records, particularly for a larger request, indicating that more time is needed. Certainly, anytime a requester voluntarily agrees to give the town additional time to respond, I always recommend that be put in writing, just as a best practice, so that if an appeal has been filed, we can demonstrate the town has really been working with the requester. Some important timeframes in terms of business days: if it's in writing, the request is deemed received on the first business day following receipt. So if it came in today, it'd be tomorrow, but an oral request is received on the day that it was actually made. So that's because it would be received at the time its public records request is orally made. Some required elements. Obviously, this is going to be more of a consideration for town personnel and staff, but certainly so everyone's aware, we always want to state the date and the request was sent and when it was received. We want to describe the records. And so if you're asked to if you're called upon to produce records or say which records you don't have or confirm what records you have in your capacity as a town board or commission member, what you'll want to provide a list of, no, I don't have this, yes, I have this, and that will make it much easier for the town to respond to the request. Certainly if there's records that go back for a period of time, there may be some records retention issues. I had a request a couple of weeks ago that was seeking records from 50 years ago, some of which no longer existed because of the records retention schedule. They no longer had to be maintained. So that's something just to be aware of as well. But the one thing just to note is, for bigger requests, time is of the essence to kind of confirm what is or is not there. So just be on the lookout if you see an email given the response period. The town is able to ask for an extension and certainly can charge fees, as I had mentioned before. If the town is going to charge a fee, it's the town personnel time that is required to gather and search for those records, and we'll talk about that a little bit more. But certainly these are the required elements of a response as well. So you may be asked, what is the volume of records, if there's redactions that are required to be made under the law. So certainly answering all those questions is important to finalize the town's response to a request. Fees. I often get asked this question, can we charge for the time that a volunteer public body member has to search for and locate the records at issue? Generally, the answer is no. But we certainly can charge for the coordination by a town hall employee or town personnel to facilitate the response to that request, in my opinion. And it's up to $25 an hour for the time spent responding to the request. This clearly comes up a lot for larger requests, as I had mentioned. But in the town with less than 20,000 residents, you can even charge for the first 2 hours. In larger communities with a different population, obviously you can't charge for the first 2 hours. You can, the town is allowed to charge a fee for a request and does not have to do any more work if the fee is not paid. So that's important to keep in mind as well, as you may be asked to say, how many records do you have, and provide those to the records access officer or to a department head in order to get a sense of what's there in the scope of the documents. However, if the person doesn't pay, the records may ultimately not be produced. So just another factor to think about. I just wanted to go over at this point some commonly used public records law exemptions. And I think this is important just for everyone to keep in mind, as you're aware certainly of the records that you have, you're aware of your jurisdiction, you're aware of what you see, just to flag these in case you have to deal with this in producing or maintaining your records individually. We are allowed to withhold certain information under Exemption A that's exempt under state and federal law. And basically, the Public Records Division has identified certain statutes that expressly state that there's confidentiality for certain categories of records, or it's implied in the statute that the records are such a sensitive nature that we can't provide them as a matter of law. I've given some examples that we often see it come up more often than not. Quarry information that comes up sometimes in the liquor licensing context. I've seen it, as well as, of course, police department records. Personal information under Chapter 93H. If records include records in your possession or records you're entitled to see as part of your role in the town, records that involve social security numbers, driver's license numbers, financial account numbers, credit card numbers, checking account numbers, savings account numbers, that personal information is required to be taken off before those records are produced in response to a public records request. So always a good idea to check. Information protected by HIPAA, that's a federal medical information privacy law, as we all know when we go to the doctor, and it's in the news quite frequently now. Medical information obviously has heightened protection under state and federal law, as well as, and this has come up quite often for boards of health, COVID information about specific individuals. There are state law protections for that as well. So we'd want to just be conscious of any information disclosed. FERPA, this comes up obviously more on the school side, but just something to keep in mind. FERPA is the Federal Education Rights Privacy Act that deals with student records. And there's also a separate state statute and regulation that deal with confidentiality of student materials. So those are Exemption A, commonly used exemptions that I see quite frequently. Exemption C, previously this predominantly related to individuals' personnel files, as well as medical information or files that were in the possession of a public entity. There has been a change to this exemption. It went into effect as part of the police reform law at the end of 2020, early 2021. And now there's a balancing test that's done for these types of information. Generally, we take the position that if there is personnel information or intimate details of a highly personal nature that information we would want to carefully review and evaluate to determine whether it could be disclosed or whether it's confidential. This comes up, in my experience, in a variety of different contexts, certainly police records. I've seen it in personnel records. I've seen it in records that are submitted to the town for different permits, abatements. There's often times where people provide personal information. So we just really want to be conscious of not disclosing too much and being sensitive to individuals' privacy interests. Exemption D, that would pertain to a memorandum, for instance, if there's something being negotiated, something that has not come to a final conclusion on the policy side, there may be a basis to withhold that under exemption D. Obviously, we'd want to look at that to see if it, if exemption D applies to any policy positions or papers that deal with the deliberative process. Exemption E comes up quite frequently, particularly for public body members. If there are personal notes that someone has made that are not shared, either with a town official or employee or someone else, and they're not part of the town's file, then those notes generally can be exempt under exemption E. If they're incorporated into something else, it might be a different story. But if someone it's their habit to take personal notes and keep them to themselves, there may be a basis to say that those are subject to keeping them to yourself under exemption E. Exemption F often comes up in the police side as well. It allows the complete withholding of ongoing investigations until the disclosure of these records will not impede or affect the investigation. So if you have an open police investigation, obviously if information is prematurely disclosed, it could taint that process. So those would be withheld potentially under that exemption. It also allows the town to redact or not disclose, in my opinion, the names or details of individuals who make complaints or participate in a law enforcement investigation. So this comes up quite often, again, on the police side. If someone makes a report or makes a complaint and it's under review, generally the names or identifying details of those individuals will come off the reports. The policy behind that, of course, is you want people to cooperate with investigations without the risk of their identities being disclosed. Exemption N, this we're seeing more and more requests on, particularly in the cybersecurity context. It is the exemption that would allow the town to withhold records if the custodian believes that the release of the records would jeopardize public safety. I was speaking at the training earlier today, but we've seen a significant increase in records requests dealing with the town's IT infrastructure, virus software, et cetera. And certainly if the town believes that providing this information or making it publicly available would pose a security threat, then exemption N may apply if redactions aren't possible. So just another one to keep in mind as we navigate the public records law. Exemption O, public employees, home telephone number, home address, personal email addresses are also confidential. There's also a separate statute under Chapter 66, 10B that applies to the confidentiality of law enforcement addresses. So just something to remember as well. So it's not infrequent that people will file appeals when they're unhappy with a community's public records response. I probably handle several hundred a year. Last year, based on my review of the Public Records Division database, I believe there were about 3,000 appeals to the Public Records Division following responses to public records requests. They fall into a couple of different categories. The first is if there's no response given. The second is if someone's unhappy about the fee that's being charged. The third is generally if they're unhappy about the redactions or withholding of particular records. Most of the time, 95% of the time, the appeal is made to the supervisor of records. I know of a handful of cases that have gone to court directly, but generally they're handled at the administrative level initially. And the supervisor of records then issues a decision within 10 business days. There is the option for someone that's unhappy about the response to a public records request to go to Superior Court. And the risk here, and I'm just flagging this so everyone knows, is, if someone is successful or has demonstrated that the records were improperly withheld, even in part, then there is the potential for attorney's fees. So we just really want to be conscientious, as you all, of course, are, in handling public records requests. Just a couple of notes on electronic records. Certainly, we've all become very tech savvy in the past 5 to 10 years, and particularly the past couple of years. The supervisor of records has said that certain records, if feasible, should be posted to the town's website. Those include final opinions, decisions, or orders, votes from meetings, essentially, annual reports, records that are being requested quite frequently, so the town can respond to the request and say they're online free of charge. Winning bids, grants, certainly minutes of open meetings. These are all things that you have online. And public information, of a significant interest. So if there's a particular project or there's a particular permitting matter before the town, those records, if you wanted to put them online and that's feasible and you have the IT infrastructure, you could put them online. If you're seeing someone or a group of individuals make that request over and over again, it might be easy just to put them online or create a separate page for that project. A couple of best practices just to consider and go over. Certainly, if possible, to use your town issued email account for town business, and to ensure that if you hit send on an email or text, you're comfortable with that email being forwarded, printed, posted online, or tweeted. Certainly we've seen a huge increase in the use of social media, and we'll talk about that a little bit later in the training, but we really want to be conscious that when we hit send, we're compliant with legal requirements, and we're also cognizant of what is put in writing may ultimately be published and available, globally within seconds. And certainly that's something that's coming up more and more. Certainly, we also want to avoid asking for or providing personal information in public emails, including unpublished telephone numbers, medical information, social security numbers, financial account numbers, etc. I use this example, but I had a situation a while back that someone had put their computer password in an email, and then it could result in a security issue. So just be cognizant of whether that should actually, what you're putting in an email should be in an email. And certainly consider whether a formal record is required or if a phone call will do. We certainly all use email all the time. It's handy, we text, people use technology. At the same time, the use of technology certainly has to be balanced with the fact that the records are subject to the public records law. So just to flag that as well. Before we go into the next topic, I just wanted to see if there were any questions, and maybe Justin could help me, if necessary, coordinate that.
Yes. So we are going to start in the room here, and then we're going to go to see if anybody has questions who's joining us virtually. So we'll start in the room, and I'm going to move the microphone over. If anybody has any questions, if you wouldn't mind just coming up to the mic and just stating your first name and stating what board and committee you're on, please.
Hi, I'm Mike Dick with Capital Budget Committee.
Mm-hmm.
On the exemptions, exemption O, our volunteers, all of us here are volunteers on town boards. We're not employees of the town, but are we considered public employees? And so are we exempt from providing personal email, home address, and home telephone number?
You do not need to provide your, thank you for the question, Mike. You do not need to provide your personal, obviously, if you're elected, it's different because that information is going to be publicly available. But if it's for an appointment, that information, I believe the supervisor has said that that can be withheld so long as there's a request to do that. And obviously, if someone's using their email address regularly for town business, it might be difficult to redact a Gmail account off of it. But certainly home address or home phone number or personal cell phone number, I would take the position that it could be redacted under O. And exemption C as well.
Another question that follows on the status of ourselves as volunteers. For all of this material that you've just presented, for the most part, like 95% of it, seems to me to be covered by the town manager's office. Do I have that correct? Or is there a responsibility that volunteers on town boards have under all of these laws and requirements that you've just outlined?
Sure. So certainly.
Thank you.
Oh, thank you for the question, Mike. For the public records law, you are correct. I mean, generally it's handled more on the town hall side versus individual board members, right? I would just point out that the public records law is very important because volunteers still have a requirement to maintain records from their official business with the town under the records retention requirements. So I go through all of it, not necessarily that public body members are going to be formally responding to public records requests, but just so you're aware, not you, Mike, but everyone's aware of the fact that the records that you create or receive are subject to the public records law and also subject to the records retention requirements. And so if there is a public records request, any public body member would be asked to produce what they have in his or her own possession and provide that to the town, whomever is going to respond to that request. And so individual, board, committee, and commission members do have an obligation to maintain records relating to their role in town government. Does that answer your question?
Thank you.
Great. And I think we're going to get into the next portion on the open meeting law, which has more direct relationship to your day-to-day. But if a public records request comes in, you would have to assist with response, and certainly the records retention requirements do apply as well.
Does anybody have any more questions here? All right, let me check virtually real quick. Let's see if we have any hands up.
Thank you, Justin.
Absolutely, not a problem. And we have no hands up, so I will send it back to you.
Great, thank you. I am happy if you want to poll the room, if people want to break, or if they want to just keep going, however people would like to proceed. We probably have another half an hour, 40 minutes, depending on questions.
What do we think? Keep moving?
Keep going.
All right, we'll keep going.
Okay. All right, we are shifting to another sunshine law, which is the open meeting law. And this has, in my opinion, more direct relation to all of you and your roles in town government. The open meeting law is very familiar to all of you. As you know, it's essentially how public bodies operate in Massachusetts. There was a significant overhaul years back. We now have a body of determinations, what they're called open meeting law determinations and declinations, that really take the open meeting law itself, take the open meeting law regulations, and we understand and we have a very clear picture of how the Attorney General's Division of Open Government is interpreting the law and the regulations following complaints by individuals. As I said in the beginning, I'm really here to provide an overview. It's not in response to anything else. That being said, I think it's a really good time, every year, every 2 years, to do a refresher on this, to say, here's where the law is now, here's what the determinations are, here are some best practices that can really make it hopefully a little bit easier on all of you as you perform the essential functions of your public bodies. So I start with that premise, and then we'll move into the substance a little bit more. And again, happy to answer any questions when we get through this section. I always like to start, and I apologize if this is very tedious, but I think it's really important to start with some definitions when we talk about the open meeting law. And why that is because we all understand what the open meeting law is, but I think it's really important to understand that it controls more than just necessarily what occurs during a public meeting or a public hearing. So we know that a meeting is a deliberation amongst a quorum of a public body to discuss matters within the jurisdiction of the body. We meet, conduct business, we take votes, that's how things get done. What's important to note is, well, what is a deliberation? A deliberation is an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body. So we just need to be conscious of that as we go through some of these open meeting law principles to say it's not just really what occurs during the meeting itself, but can be triggered by what occurs outside of that meeting. The definition of quorum is known to us. It's a majority of the full complement of members, except in limited circumstances. And certainly a public body is broadly defined to not only include the ZBA, Conservation Commission, Planning Board, but also subcommittees, Finance Committee, we know, but also subcommittees that are created by a multi-member board as well. And so that question comes up quite frequently. A committee creates a subcommittee to advise itself on certain matters. Is that subcommittee subject to the open meeting law? Generally, yes. There is a test that has to be done, but just to be cognizant of when subcommittees are created, it would also trigger the requirements of the open meeting law. So there's some big legal requirements. I've tried to break them down into 3 different topics just to make it streamline it a little bit. And my brain works in chronological order, so that's how I've done it. First, we deal with notice, the timing of the meeting, the location of the meeting, including ADA accessibility, or if public body is meeting remotely, remote access information while the remote provisions are in place. We'll talk about that a little bit more. Governor's office just signed the extension of remote participation if the town elects to do so until the end of March 2023. Level of detail in the notice, we'll go over that. How much detail has to be included, just to make sure we have best practices for that principle. And purpose. There is a presumption that public bodies will meet in open session. There is limited authority to meet in closed or executive session. There are specific enumerated reasons for when that can happen. And absent those reasons, the presumption is that a public body will meet openly. And again, that goes back to the sunshine laws. Minutes, what has to be in there? We know that there has to be content. We'll talk about how much content is necessary. Timing within 3 meetings or 30 days, whichever is later. The meeting minutes have to be drafted and approved, and approval is the last step of that. And we'll talk a little bit about that approval process as well. So going back to the fundamental principle of meetings, we know that a meeting includes a deliberation amongst a quorum to discuss matters within the jurisdiction of a public body. The term meeting does not include an on-site inspection of a project or a program, provided that members do not deliberate. In my experience, and I handle a lot of open meeting law complaints every year, that requirement is interpreted very strictly. Sometimes a best practice would be to send, one member to an on-site inspection and report back to the full board or committee. Sometimes, there might be a quorum that wants to attend and no one will speak. And then you come back and deliberate again at an open meeting. So certainly that comes up from time to time in terms of on-site inspections. The term meeting does not include attendance by a quorum at a public or private gathering or social event, provided that members don't deliberate. This could include, obviously, community events, parades, public service days. Obviously, all of you are very active in the community. I'm sure you see each other in the community, both at social events or private gatherings, or public events as well. You just want to ensure that you're not deliberating on anything within your board or committee or commission's jurisdiction, or give the appearance that you're doing so. I've handled multiple public open meeting law complaints where someone thinks that something's happening because of the appearance of it. So just be conscious of your surroundings, but a meeting does not include those particular items, and the Attorney General's office acknowledges that people that are involved in the community will run into each other, and will discuss other matters besides what's before their public body. So one thing that we've seen a huge increase in complaints about is emails between or among board members. And so I just note that an oral or written communication, including, email between a quorum of the public body with certain express exceptions, can potentially constitute deliberation. So just to be acutely aware of that. The exceptions to this are really meeting agendas. I call them the scheduling things. Meeting agendas, scheduling or procedural information. Are you available on these dates in August? Is September better? How long do we think the meeting will go? Should we list this topic for this? We have a long agenda for this meeting. Really scheduling matters. No opinions of a governmental body should be expressed in an email to minimize any risk of deliberation. Reports or documents, if an individual sends documents out, that's fine, so long as it's clear that those reports or documents should be discussed only at an upcoming meeting, and that any communication does not express the ideas, feelings, beliefs, opinions of a member of that public body. So it is a fairly narrow exception in terms of what can or cannot be disclosed outside the context of that meeting. Just wanted to give some practical approaches for this. If you're attending a meeting of another body or social event, again, avoid creating the appearance that you're discussing municipal business or something before your public body. If you're attending a site visit or a meeting of a public body, you might want to consider posting a follow-up meeting about that. If there's going to be sharing of opinions or beliefs, and other people may want to respond. And if a member wishes to speak at a posted meeting of another public body, even if it's remotely, webinar format, Zoom format, etc., the member should make it clear that they're speaking on behalf of him or herself as an individual, and that they're not representing their public body at that meeting in the event there are more people that show up and they all say, I'm coming from this public body as well. And alternatively, this comes up a lot during town meeting season, there may be some matters that have to be discussed jointly, and that's fine. It can just be a joint meeting. It's held at the same place and time, and that way both public bodies can discuss matters within their jurisdiction and be efficient in terms of conducting town business. So email is explicitly addressed in the open meeting law. A quorum of a public body cannot, and the Attorney General's office is very clear on this, use emails to share their ideas, feelings, or beliefs, either serially or in a single email. So that would be one member communicating to the entire complement of the public body, or alternatively, one person forwards it to the other person forwards it to that, and by the time the email chain is done, everyone has a sense of everyone's opinions on a particular topic. In addition, the Attorney General's office has said you cannot use a non-member, town personnel, a staff person, etc., to avoid this serial communication. If a quorum of the public body has seen this email thread, so to speak, it could be potentially problematic under the open meeting law. I always say beware to reply, beware reply to all on emails. You know, some public bodies that I work with will put something at the bottom of their email that just says, please do not reply to this, or please hold for discussion at our meeting on such and such a date. Certainly a little, signature line at the bottom sometimes does the trick, but really limit the use of emails to scheduling and try to avoid using email to undertake any business. We should assume that any email could, of course, be forwarded to an unintended recipient, or it could be produced in response to a public records request, which then could trigger open meeting law requirements. And so you just want to be very cognizant of the use of email. We also know, based on various determinations from the Attorney General's office, that social media is also subject to the open meeting law. So some practical approaches as well to avoid open meeting law violations. As members of public bodies, you don't want to direct your comments online to other members of the body. If a matter is directly involving an issue before your board or commission or committee, consider not engaging, or be thoughtful about the manner in which the comments are made. So just a new and emerging area that we're seeing more and more complaints on. I've just given here, we don't have to go through all of these in detail, but some examples of email and social media deliberations based on determinations from the Attorney General's office, voicemails, posts or blogs that were sent around to various members and people would comment on them, web-based discussion groups, chat rooms, social networking, whether it's contemporaneously, entire board sees it, or in a serial fashion. So just some things to be conscious of. Okay, so now we're going to get into a little bit of the timing of meeting notices, and then we'll transition over to meeting minutes as well. We know that the chair sets the agenda for meetings, and the requirement is that the meeting notice be posted at least 48 hours in advance, unless there's an emergency, and the 48 hours doesn't include Saturdays, Sundays, and legal holidays. So for a Monday meeting, notice must be posted on a Thursday. Monday's a holiday, then the Tuesday is as well. The notice has to state the date and time that it's posted, and usually that's done as a matter of course. And if it's revised within before the 48 hours expires, then you would want to put the time of the revised posting on as well. The notice has to include the date and the time in the place of such meeting, and a listing of the topics that the chair reasonably anticipates will be discussed at the meeting. And this is the language from the open meeting law. If a meeting is held remotely, the information should also be put on the meeting notice. What we know is that the topics have to be, quote, sufficiently specific. And the example I always use is if you had your meeting notice or agenda and you looked at it and you didn't know anything about your public body, would a member of the public look at the four corners of the document and say, I really want to attend this meeting because a building permit for 123 Main Street is going to be discussed, and that's of interest to me. It has to have enough detail to alert members of the public that may know nothing about a particular matter, would look at it and say yes or no, I do or do not want to attend. We recommend that regularly occurring items should have more detail than just generic placeholders like correspondence or old or new business. That's fine, but you do want to include, if you can, some more specificity in there, again, to alert members of the public to say, yes, I would like to attend, this grant is being discussed, this project is being reviewed, this liquor license, this permit. So just a little bit more detail, the address, the property, the applicant's names, all of those details really round out and alert members of the public. Again, going back to those sunshine laws, what's being reviewed by your public body. Some additional best practices to consider. We're certainly cognizant that each community has its own practices and procedures, for how it does its meeting notices, but some other things just to keep in mind is not to use acronyms or abbreviations. So to spell out terms that may not be familiar with the general public, that might include grants, some programs, statutory references, or anything that an abbreviation might be known to you as you do the work that might not be known to a member of the public. If you do need to include an executive session, obviously cite to the specific references, quote the text of the executive session purpose, so long as it won't impede the town's position on a particular matter. And certainly that's something you can always coordinate as necessary with the town manager's office or town council's office if you need assistance with that. We should generally recommend avoid general shorthand references such as contract negotiations or hiring without further detail, if you can, for a position or a person or something along those lines. Obviously, an individual look should be granted on all of that to make sure if it's the right purpose. If you do have an executive session, it's the only matter on the agenda. The notice must also indicate that an open session will be held, because you open the meeting in open session and then you enter into executive session from there. So you always have both on there, even if there's no other open session business for that meeting. So one question that comes up quite often is if a matter is not anticipated by the chair, can it be reviewed? The determinations that deal with this, and there are quite a few, they state that matters not reasonably anticipated by the chair must be added to the agenda after the posting deadline to the extent feasible. So depending on how far in advance your public body posts their meeting minutes, you may have time if something new comes up. But if you're in the 48-hour window, you would want to post it anyways, and then update the time and date of the update. And what we know is that matters not reasonably anticipated by the chair under the open meeting law may be discussed and acted upon, but it is a pretty fact-specific inquiry. So it's not unusual for the Division of Open Government to say, was it really not anticipated? So just keep that in mind as well. And the Attorney General's office does recommend that unless a matter requires immediate attention, best practice would be to put it off to a later meeting and include it in a posting 48 hours in advance. Obviously, if it's time sensitive, there may not be time for that, but that's certainly the recommendation of the division. So I had mentioned before, timestamp the notice to ensure an accurate record exists of the filing. That's something that's generally done through the town clerk's office. And a meeting may not be continued from one night to the next night unless it's posted each and every time. And certainly the notice required under the open meeting law does not substitute or otherwise supersede any other notice requirements, for instance, under 40A or any other applicable laws. So you'll want to double check notice and publication requirements separate and apart from the open meeting law that may require additional time to post. So emergencies, as we get into summer storm season, it's always the summer and the winter. So summer storm season and winter blizzard season, and other, public health and safety emergencies, power outages, etc. Just a couple of things to keep in mind. And this is really, in my experience, triggers or affects some boards more than others. We know that poor planning does not equal an emergency. So if there is an emergency, you are allowed to meet without the 48 hours notice, but some practical considerations. Public health emergencies, certainly natural disasters and public safety issues, road closures, etc., generally do qualify as emergencies as long as the town can demonstrate it had no knowledge of it before the emergency came up. Before COVID-19, The majority of emergencies were generally limited to weather or public safety issues. Now it's a little bit broader, though we know that not every public health emergency is time sensitive, so just something to keep in mind there. Some practical recommendations: you still want to comply with the law to the extent you can. So to post if you can, even if it's under a shortened time frame. And you really, if there is an emergency, want to limit deliberations to just that emergency matter. Many of you will recall years ago, it was, I think 2007, 2008, there was a terrible ice storm that hit parts of Massachusetts, mostly in the western part of the state, and there were declarations of emergency that had to be made. And really, you would want to limit your discussion to just the matter at hand, which was the storm, and not bring up or discuss other topics. If there is an emergency meeting, you still need to take minutes of the meeting, and then you need to review them and incorporate them into your next meeting minutes. So essentially ratifying the action that was taken during the emergency meeting. So you would want to post, if you have time to post an emergency meeting, you would want to consider posting a regular meeting as well to ratify that action taken. But certainly fact specific and narrowly tailored, but it can be used in the event of emergencies. Just going to cover quickly conducting remote meetings. You all are certainly familiar with that by now. I just wanted to flag a couple of things in light of the recent legislation that continued the prior suspension of portions of the open meeting law now through March 31st, 2023. We know that ordinarily all meetings of public bodies must be held in a public place that's open to and accessible by members of the public. During COVID-19, the governor issued an executive order basically suspending certain provisions requiring open and accessible public place meetings. And that legislature has extended this authority several times. Recently, 2 days ago, it was signed into law on the 16th, which now extends it through March 31st, 2023. There are a series of bills that are being debated in the legislature, some having permanent measures to try to determine if there are going to be hybrid meetings in the future, technology requirements, et cetera. We're, of course, monitoring those closely in any legislative developments, but as of today, we know that the authority to allow for flexibility as needed or as determined by each and every community individually is through the end of March 31st, 2023. What this allows, to the extent the town wants to use it, is that public bodies are not required to hold meetings open to the public in locations open to the public, as long as there's adequate alternative means, and that would include telephone, internet, or satellite that enables the public to clearly follow in real time. So the recent legislation essentially just dealt with the date by pushing that date out from July 15th, 2022 through the end of March 2023. We know that if public bodies are meeting virtually, that the meeting notice has to have instructions, Zoom link or password. Just a little practice tip, you want to make sure that the meeting notice is updated from any prior notices or agendas. And if you're doing a hybrid meeting where some members are participating in person, others are participating remotely, the chair must identify, who is there in person versus remotely, and that's referenced in the meeting minutes. The chair would also announce if the meeting is being recorded, and all votes taken in a virtual meeting or a hybrid meeting, some in person, some remotely, must be by roll call vote. Everything else applies under the open meeting law, the notice requirements, the meeting requirements, everything else does apply. There have been some determinations in the past year, so I just wanted to highlight those for everyone here tonight regarding technical difficulties. If there is a remote or hybrid meeting, if there's a technical problem that prevents the meeting from being accessible. So the live stream goes down or there's volume issues. The Attorney General's office has said that the meeting should be paused or rescheduled depending on the severity and the length of the technical issue. And so I've given some reference to different determinations here. So continuing the meeting and posting a recording doesn't cure the violation. Essentially, that members of the public must be able to attend or view the meeting as it happens. So those were two determinations from 2021 that I've just referenced here. If technical difficulties result in a remote participant being disconnected from the meeting, the fact and the time of the disconnection should also be noted in the meeting minutes. So that's just another practice pointer as well. I get this question quite often. I'm sure you all do too, as public body members. As with public meetings conducted in the normal course, public participation is not technically required in general business meetings of a public body. So public comment, while most public bodies have it, is not technically required. If you do allow for it, members of the public must be able to communicate with members of the public body in real time. And so you can't pick and choose who's going to speak. It has to be in a content neutral way to satisfy free speech requirements. And this is the same as if you're meeting in person or remotely. We just always want to be cognizant of First Amendment and free speech considerations. If public comment is allowed, obviously different in the public hearing context where you would need to allow the public an opportunity to comment. Executive sessions, very technical as we talked about before. The process for having an executive session is certainly noticing the executive session in advance. You cannot have an open meeting and then halfway through a discussion say we're going into executive session to speak about this. It has to be posted on your meeting notice in advance in accordance with the open meeting law. The process is you convene an open session beforehand and you state the purpose of the executive session similar to what's on the agenda without compromising the purpose for which it was held. So the classic example for that is obviously if the town is considering pursuing litigation against someone and that's not publicly known, or it may impact the town's litigation position. If the town needs to go forward for a particular matter, there may be reasons why you wouldn't list that. Generally speaking, the Attorney General's office has said that you need to provide some specificity with litigation unless there are specific reasons not to. You're going to take and record a roll call to go into executive session, and you're going to announce if the open session will reconvene afterward. Certainly, you'll maintain the records, exhibits, and documents used in reasonable proximity to the minutes, and you're only going to discuss the matters cited. And so if you have on your meeting notice that you're meeting an executive session under the purpose for which you've had an executive session before and purpose 7 to consider releasing executive session minutes, you're going to stick to that discussion point and not talk about other matters. So just discuss the matters that are cited on that particular executive session. And all votes will be taken by roll call vote in executive session to have a full record of the meeting at issue. I referenced this a little while ago, but if the executive session is anticipated, it must be listed on the meeting notice without compromising it. And the vote has to have the same. If you ever need help in terms of what motions should be made or what language should go in a particular meeting notice for a real estate transaction or review of executive session minutes or litigation or a complaint or something along those lines, certainly reach out to the town manager's office and we'll be happy to assist. Meeting minutes, just some best practices. We are seeing significant increase in public records requests and open meeting law requests for meeting minutes. Meeting minutes must be kept for all meetings of public bodies. They have to include the date time, place of the meeting, and the members present or absent at that particular meeting. The meeting minutes do not need to be a transcript. They do not need to be verbatim. They do, however, need to have a detailed, excuse me, a detailed summary of the discussion of each topic to allow someone to understand what occurred at the meeting. Similar to what I had mentioned with the meeting notice or the agenda, the same for meeting minutes. You want to be able to, a member of the public would pick up your public body's meeting minutes and really understand what was discussed, the general consensus of the meeting, what occurred, the votes taken, any decisions made. Certainly any documents or records that are used by the public body will be part of the record, but not part of the minutes. That would include obviously an application, a permit that issued, a plan that's referenced. If there's materials provided by a member of the public that the public body considers, any of that you would want to reference as part of the record of that meeting. Minutes must be created and approved in a timely manner. The Attorney General's office has said that the best practice is that the approval of the meeting minutes, the draft meeting minutes, must occur generally within the next 3 meetings or 30 days, whichever is later. Certainly there are circumstances, we all know, where there's staffing constraints or absences or a significant amount of work for that public body to do in terms of drafting meeting minutes. If there's an increase in meetings or the meetings are lengthier, but certainly this is the general time frame that the Division of Open Government is looking for. They do understand that cities and towns have limited resources and staff time, and it's a significant amount of work to draft the meeting minutes, but certainly we want to try to stay on track with this time frame. Minutes of a public body, open session minutes, are public record as of the moment of their creation, regardless of whether they've been approved or not. Upon request, minutes must be made available within 10 days, and they are subject to disclosure even if they're in draft form. Because many public bodies are meeting more often, since remote meetings have been authorized, certainly just you want to stay on top of the meeting minutes as much as you can, while conscious of obviously everything else, all the other public business that you have to take care of. Executive session minutes, they're also public records, but under the law, they can be withheld until the purpose of the exemption has been met. So for instance, the most common example would be if there's pending litigation involving the town and a public body needs to discuss that litigation under Purpose 3. If that litigation is ongoing, while you would routinely review it, you might say the litigation's ongoing, the meeting minutes cannot be, the executive session meeting minutes cannot be disclosed. You do want to review the executive session minutes periodically and determine whether the purpose has expired or not. Certainly it can be done under Exemption 7 or under the original purpose that you went into the executive session for. No fee can be assessed if there's a request for executive session minutes. And it's a 2-step process where the public body would have to decide, can they be released? Has the executive session purpose expired? And even if they can be released, are there any exemptions to the public records law that would apply that may allow portions of those meeting minutes to be redacted? So again, going back to my litigation example, if the town is involved in litigation, the public body has met. I'll just give an example. The planning board has met on this litigation 6 times. The case is resolved. A portion of those meeting minutes involved privileged communications with counsel. We would potentially redact a whole or a portion of those meeting minutes depending on the substance of them. So it's really that 2-step process. Can they be released? If so, are portions of them exempt? And so certainly if there's a request for those, we can walk through that process in detail based on the facts and circumstances at hand. This is the enforcement process. I just really wanted to give an overview. As I said in the beginning, I deal with a lot of open meeting law complaints. This is just something I'm identifying for everyone, just so you all have the information. But certainly you're probably familiar with it as well. There's a 3-step process. If an individual claims the open meeting law has been violated, there's a complaint that gets filed with the public body. And then the public body has to review that complaint within 14 business days, meet on the complaint, identify its response, and issue a response to the Division of Open Government and to the complainant. Following that, if the complainant is satisfied with the public body's response, that ends that portion of the enforcement process. However, an individual can also seek further review by the Division of Open Government. They have an enforcement division that would the attorneys look at the allegations of the complaint, look at the public body's response, and determine whether it's sufficient or not under the open meeting law, and issue a determination after they've reviewed. So it's essentially a 3-step process with the third portion of that not getting triggered unless the complainant wants to seek further review. This was the process I had mentioned. If there is an open meeting law complaint, the matter has to appear on a meeting notice. The open meeting law complaint can be reviewed either in open session or an executive session, and certainly town council's office can assist if you need an agenda item for that. The body has to acknowledge receipt of the complaint and would deliberate regarding a potential resolution and to review the allegations. Essentially, there's a vote to determine what the response is by the public body that then goes to the Attorney General and the complainant. There are times where, mistakes occur, and certainly it might be a situation where further remedial action has to be taken, or further public deliberation has to take place. So I've just included that as well. If there is a public deliberation or properly posted meeting, that it may potentially cure if there was a violation that occurred. So I just want to include that there for your reference as well. The Attorney General's office has a range of enforcement options. This is set forth in the open meeting law itself. Essentially, it can order future compliance with the open meeting law. It can require attendance at a training session. It can order that meeting minutes be created or disclosed. For instance, if there was a meeting at issue that involved, or a complaint that involved meeting minutes, it can nullify action taken, or if it goes down after a hearing, or further review after a hearing, there's the potential for fines. Certainly, in my experience, that's a very a rare outcome in terms of open meeting law complaints. The goal is certainly to ensure compliance and to ensure that everyone understands the requirements under the open meeting law. Generally speaking, there's a wide range of options before we get to the fine provision, but certainly wanted to just identify it in case there's any questions on that as well. Before we get to questions, I just wanted to include some great helpful resources. First, maybe I should go backwards. Our resources, I think, are really good. We have public records law resources on our website. We also have a significant amount of open meeting law resources on a wide range of topics, meeting minutes, remote meetings, certainly meeting agendas as well, executive sessions. They're all available online at that website, as well as a whole public records section as well, and other topics in terms of anything that you may deal with as a member of a public body. So hopefully that's a great resource for you. In addition, the Attorney General's open meeting law website, there's a guide that was recently updated a couple of years ago that goes through all of these topics as well that I covered tonight. Certainly that's a great resource for public body members and just a good book to have in case there are any specific questions that come up as you perform the duties of your public body. The other thing I just wanted to mention is the Secretary of the Commonwealth's Guide to Public Records. There's a significant amount of resources in that guide as well. It was recently updated in February 2022, including that change to Exemption C. It also outlines some specific topics that would be of interest to public body members, like the records retention issue that I had mentioned when Mike had that good question earlier. So just wanted to make sure you had those materials as well. Our resources also include Sunshine Law questions on conflict of interest and common questions on that topic as well. So I'm happy to turn to questions now, but wanted to make sure you had all this information available to you so that you can navigate the complexities and the fun of serving on a public body.
We'll start with our virtual folks. Do we have any virtual folks? I don't see any thumbs up or hands up here. Anybody else here have any questions? Okay, feel free to come up to the mic here and ask a question. And if you just state your first name and just say what committee you're on.
Susan Bryan, I'm on the Harbor Committee. I just wanted to be clear that I understand this correctly. The deliberation stuff is not actually a problem unless it's amongst a quorum, right? So unless there's a majority of the people on the committee, then anybody can talk about anything. Is that true? Because I had misunderstood that before.
Sure. Thank you for your question, Susan. Yes, the open meeting law is triggered when there is a quorum of a public body that is discussing or deliberating matters within its jurisdiction. I think the risk is always, and this goes into the serial communication portion that I covered, and I can go through it a little bit more because I know it's a lot of material. The risk is always if you have a 5-member public body and one person sends it to one person, another person sends it to another person, and then you end up with a quorum of the public body involved in these serial communications. That would constitute a deliberation amongst a quorum of the board or the committee.
Anyone else? Yep. Sorry. Continue. I didn't mean to interrupt you.
Oh no, I was just going to say that's where the serial and some, it comes up very inadvertently. One person forwards something to one person, the other person forwards it to something else. And then by the end, and this is completely hypothetical and I'm speculating, but it then, if it goes to more than not a quorum, it can invoke the provisions of the open meeting law. Good question, Susan. Thank you.
You can come on up to the mic and just state your first name and just state what committee or board you're on, please.
Hi, I'm Steve Wenner, a member of the Cohasset Alternative Energy Committee. I just want to take the opportunity to ask a question that doesn't directly apply to Cohasset, but do the open meeting and public records laws apply to state public bodies?
They do apply to state agencies. That's correct. The legislature and the courts are exempted, Steve.
Okay, good, thank you.
You're welcome.
All right, anyone else for questions? Yeah, could you just step up to the mic just so she can hear you? Thank you.
Susan again, from the Harbor Committee. So when you were talking about the commonly used exemptions, exemption D, can you talk more about that? Deliberative process documents, including those records on matters for which policy positions are being developed, including legal advice.
Sure.
So what would that include and why it's the double negative? It's exempt from what again?
So exemption D is under the public records law, and it's probably more of a consideration for town employees versus public body members, but this is how I could see it coming up for public body members. If you had a policy matter that was being considered and you were provided a copy of a document prepared by an expert or prepared by a consultant or prepared by a town department head or town personnel on a particular issue. And that policy was still being developed. So it comes up quite often. I'm trying to propose permitting proposals or TIF agreements or, particular redevelopment proposals are some examples, Susan, that are coming to mind as I sit here right now. And it may say, we looked at this option, confidential memo for deliberative process only, ongoing policy development. So sometimes these are circulated internally with town personnel or staff. And those would be considered confidential if there's still policy discussions ongoing, right? Because the whole point is you want the town to be able to develop policy positions confidentially. Now, the wrinkle here for public bodies is that if that memo is discussed publicly in open session, we know that the open meeting law says that documents used as part of a public body's meeting are generally subject to disclosure, right? And so if someone asked for a document, right, on that we said, oh no, it's exempt under exemption D, the counter argument to that would be, well, no, it was used by, the Harbor Committee in developing its position, and therefore it's incorporated in the meeting minutes and may be subject to disclosure. It's very technical. I understand, probably boring you, but there are memos related to ongoing policy positions that often towns have someone prepare. If they're not publicly disclosed at a meeting, exemption D may apply. However, if they are publicly discussed by a public body, more likely than not, and reviewed and used under those 3 prongs that I put in the slide, more often than not, they would most likely be subject to disclosure because they would be referenced in the meeting minutes for that meeting. Does that make sense?
Yeah, it's tricky to figure out how to work effectively.
It is. I mean, I think that it's the purpose of exemption D is really for internal working documents or internal policy positions being developed by the town that are not publicly discussed, right? That the premature release of those materials, certainly if there's litigation, for instance, right? This is sort of the classic example with exemption D. The pros and cons of a particular case or a litigation position, and perhaps a consultant prepares an analysis or town council prepares an analysis. Not only would that be privileged, right? It would be protected by the attorney-client privilege as town council to advise the Harbor Committee on a particular issue, but it also would be potentially discussed in executive session. Then it would be easier to invoke, right? Relating to that litigation.
All right, thank you very much. We have one more brief comment from Select Board Chair Jack Creighton. Chair Creighton, step up to the mic and you have the floor.
No, thank you. First and foremost, I want to thank the members of the boards and committees for attending this. Your work keeps Cohasset the special place that it is. I want to thank people who are here and the people at home. I want everybody to know that if you do have an issue with any of these things, pick up the phone. We have town council. We have staff at town hall. They will advise you. We want to make sure that when you volunteer your special time, that you don't inadvertently cross some trip line and get yourself in trouble. The town and the town employees and town council are here. If you inadvertently make a mistake, as you can see, it's easily cured. What you don't want to do is, if you're wondering about it, say, well, maybe it'll go away. We'll walk you through it. There's no intent to have anybody have any issues. And again, most importantly, thank each and every one of you for showing up, and the people at home, thank you very much. And thank you. KP Law is the best, right?
Wonderful.
Thank you, Chair. Thank you.
Thank you so much.
Thank
All
you all
right.
for your time this evening. Certainly, if you need anything else, don't hesitate to let me know. And I appreciate all of you participating, and I appreciate all of the great questions on these really interesting issues. So thank you so much for your time, and thank you to Chris as well for all of his effort in coordinating this in his office as well. Thank you.